Alrighty, guys. Bienvenidos. Welcome. I'd want to thank my class, Political Science 190, with Dr. Percival. Did a lot of really hard work, and it's been pretty cool lately. So good job to you guys. A big shout out to Professor Percival and Professor Curran Percival as well. They did really well. We're going to turn our attention to the issue of capital punishment in California. This election cycle, California voters will be asked to vote on two competing measures on the death penalty: Proposition 62, the Repeal the Death Penalty Initiative, and Proposition 66, the Death Penalty Procedures Initiative. Ellen Kreitzberg, a law professor at Santa Clara University and an expert on the California death penalty, is joining us to argue in favor of Proposition 62. We also have extended invitations to the No on 62/Yes on 66 campaign, but unfortunately representatives were not able to attend tonight. As a result, the structure of this panel will be slightly different from our Prop 63 panel. Professor Kreitzberg will outline her arguments for Prop 62 in a 5-minute presentation. After that, Professor Kreitzberg will have 10 minutes to field questions from us, me and Jade and I, the moderators. We will also have some time for questions from the audience. Students are walking around with note cards upon which you will write questions or can write questions. They will give us the questions, and we'll try to ask as many of these as possible in the time we have. Our speaker will have 90 seconds to answer each audience question. So Professor Kreitzberg, if you want to go ahead.
Thank you. So first, let me start by saying that I hope that each and every one of you are registered to vote for this fall. This may be the most important election that you will face in your lifetime. It is important you register, that you get people you know to register, and that you vote. I cannot underscore that enough. And I say that without even asking you how you're going to vote, but you need to vote. So I'm here to talk about these two death penalty propositions. One is Proposition 62, which replaces the death penalty with life without the possibility of parole. And I'm here to say you should vote yes on 62. The second one is Proposition 66, which claims that it will kill people on death row faster. And I'm here to tell you to vote no on 66. So let me outline some of the reasons. I told them I could argue both sides, raise the question, and then answer it, but okay, they've got a new format. So first I want to just say that the one thing everyone in California agrees on is that the California death penalty is dysfunctional. It doesn't work the way it is. We've had the death penalty since 1978. We have 750 some odd persons on death row in California, the largest death row in this country. If we start executing them next week, and we execute one a week, it will take us between 13 to 15 years just to clear all the people currently on death row, and that doesn't include the persons who will be added to death row. It is an arbitrary and unreliable government program that has cost the people in California more than $5 billion. And so whether you're a liberal or a conservative, and George Will, a famous conservative editorial writer, said the reason that people should be against the death penalty, it's another one of those government programs that doesn't work. I said it's arbitrary and unreliable, and I'll go through why. When I say it's unreliable, it's because we know that innocent people will be executed. We know there have been innocent people executed in other states. There are 700 and almost 50 people on death row. We know that some of them are executed. Some of them will be innocent people who will be executed. I work with the Northern California Innocence Project at Santa Clara Law School. It opened its doors in 2000. We don't take any cases from death row, but since we opened our door in 2000, we have had 4 persons who had been charged with murder, one of which started as a death penalty case, and luckily the jury came back with life. So 20 years later, when we were able to exonerate him, he was still alive to walk out of prison. We've had 4 persons charged with murder to have been exonerated in the few years that we've been open. There's every reason to believe there are just as many or more on death row currently. The second thing we talk about, and when they talk about why we need the death penalty, they say it's about the victims. And a lot of this should be about victims and victims' families, and I can't begin to even imagine the pain or the horror that victims' families suffer. But make no mistake, the death penalty does not help victims. First of all, we have over 2,000 murders in California each year, and yet we have a very few handful of cases for which the death penalty is selected. So we already say to 98 to 99% of victims' families, we are not going to seek the death penalty in those cases. And we know statistically, the cases in which the death penalty is selected, the most significant statistical factor is the race of the victim. The other thing why it doesn't help victims is we have over 50% of our homicides are unsolved. We have victims' families who are still waiting for some form of justice, and yet we are spending an inordinate amount, a disproportionate amount of our money in order to seek one death penalty case, while hundreds of persons whose families have had murder victims, our cases are unsolved. So we need to look at the victims of all these homicides and say, how can we bring the most justice to all these victims? The third thing is we know that the death penalty is imposed in California in a geographically disproportionate way. So 5 counties in California account for almost all of the death cases, and they're all in Southern California. We have Los Angeles, Riverside, San Bernardino, Kern County, and I think Orange County is the last one. So we not only look at counties that are seeking the death penalty, but those counties are often associated with incidents of prosecutorial misconduct. It is in Orange County, if a court actually removed the district attorney's office from any involvement in one death penalty case, because the level of prosecutorial misconduct was so great that they said no one in the office should be allowed to work in that case. So we know in California that the reason you get the death penalty is not necessarily because you've committed the worst, most heinous, or most horrible crime. The reason you'll get the death penalty is more likely because you committed it in the wrong county, that you have a bad lawyer representing you, you have an unethical lawyer opposing you, or that your victim was white. We should take those resources and punish people severely. And the punishment that Proposition 62 would replace the death penalty is you will die in prison, but you will die at the time when God takes you, not when the state decides to kill you. So it's yes on 62 to replace the death penalty with life without the possibility of parole, and no on 66 because it's not going to make the death penalty any more fair or faster.
Thank you, Professor Kreitzberg. So now we're going to have 10 minutes where we're going to ask you a few questions that we prepared for you. And Jane's going to start.
Good evening, everyone. So for the first question for the panel questions, Proposition 66 and 62 supporters seem to argue that the capital punishment system in California is broken. The key difference, though, is that Prop 66 supporters say they want to reform death penalty procedures so that those sentenced to death are actually executed and not to be stuck in a perpetual legal limbo. Should voters see Prop 66 as a compromise measure in a way? After all, a majority of California voters have long expressed support for the death penalty.
Well, Proposition 66 is not a compromise. They do have the catchy little slogan, let's mend it, not end it, let's make it happen more quickly. But my response to that is I've read Proposition 66, it does not expedite the system, and I'll give you a few examples. Right now, after you're convicted, your appeal goes to the first appeal goes to the California Supreme Court, and then the proceedings begin. Under Proposition 66, they are saying you need to file first back in the trial court, it then goes to the Court of Appeals, and then goes to the California Supreme Court. Proposition 66 adds 2 layers of appeal to the process, so I can't figure out how that goes more quickly. Also, much of the backlog is in federal court, which Proposition 66 cannot and does not even begin to regulate. We have currently people are on death row and wait almost 4 to 5 years to get an attorney before the process even begins. So there's nothing in Proposition 66 that's going to make that go more quickly.
Thank you. For our second question, Prop 66 supporters also feel that the death penalty provides closure to families. This is an argument we hear quite regularly from victims' families. Are supporters of Prop 62 telling victims' families that they're wrong?
I wouldn't begin to tell any victims' families whether they're right or wrong. They have the pain that they feel, the loss that they've suffered, that no one who hasn't been in those shoes can begin to understand how they feel or what they want. But unfortunately, what's happened in this state is prosecutors think they do know what victims want, and they give false promises to victims. They tell them they will feel better and that there will be a closure is the word they use. Well, we know that in California it will take about 25 to 30 years if and when anyone is ever executed. The case is constantly in the media. The case, when it becomes a death penalty case, is about the defendant, because that's what the Constitution and that's what the Supreme Court said it must be, that the penalty trial must be about the life and background of the person charged with the offense. So we put these victims' families in an untenable situation where the case is no longer about their loved one. Had that case been resolved with life without the possibility of parole, sentenced to die in prison, the case would be over, there would be certainty, there would be finality, and there would be the ability for them to try and resume their lives. The last point is there is some very good recent social science literature. There's a book that just came out called, where they went back and interviewed many of the Oklahoma City bombing families. And actually what they expressed was they really didn't like that the media kept talking about closure, and they found that they didn't get closure. Nothing could close the hole in their heart and in their lives from the loss of their loved one. And many of them found, again, they were disenchanted with this idea that essentially they were promised, once we kill this person, you'll feel better. Well, the loss that they've suffered doesn't get better because we kill somebody else.
Alrighty, our third question is, Prop 66 proposes to transfer a significant portion of the death sentence appellate process away from the state Supreme Court and instead place it in the hands of the superior courts at the county level. What's wrong with this in your view? Aren't there already crucial decisions made in the criminal justice system by local officials? Wouldn't this allow local communities a greater voice in how they want to administer the death penalty?
That's a good question, because there's a couple of factors that are at play there. First of all, local counties do make decisions. And if you live in San Mateo County, that district attorney seeks the death penalty about once every 10 years. Jeff Rosen, who was here in Santa Clara County, he has 2 death penalty cases that he sought in the years he's been district attorney. But you go to Riverside, where the district attorney has said, I'm going to seek it in every murder case. Now, the problem with that is, while we leave it to the local district attorneys, you're paying for Riverside's death penalty cases. You're paying for San Bernardino's death penalty cases. And if we want to make it a local issue, let the local county pay for it. So while they pay for the trial, once the conviction occurs, really where the expenses really start to add up, and make no mistake, it is more expensive to impose the death penalty than it is to keep someone in prison until they die in prison. And once that starts, those costs and those expenses are spread statewide. So it's not really a local assessment, because the cost is being borne by the rest of the state. And while I actually have no fundamental position against cases going back to the local trial court, that actually doesn't take it out of the hands of the California Supreme Court. Because the way habeas corpus proceedings work, it will go to the trial court, it will be appealed from there to the Court of Appeals, and it will be appealed from there to the California Supreme Court. Another interesting note is Article 6, Section 10 of the California Constitution, check it out, go read it, says that any prisoner in California has the ability to file their habeas corpus petition in the court of their choosing. Well, Proposition 66 says if you're a death row prisoner, you must file in the trial court. So it seems to me that Proposition 66 is amending the California Constitution. And while that may be a good idea or a bad idea, the fact is that the initiative did not follow the process required to make an amendment to the Constitution. You need more signatures to do that. There's a different procedure to do that. And they did not follow that. So the one thing I can tell you for sure is that if Proposition 66 passes, the next day the litigation will begin, and quite frankly, it will be 4 to 5 years minimum to litigate the constitutionality of that and other provisions in Proposition 66. We haven't executed someone in California since 2006. It's been 10 years. And I can guarantee you, even under this so-called let's expedite the death penalty provision, it will be 5 to 6 years more before it will be possible to have an execution.
Thank you. So I know already you've touched on kind of the financial standpoint of this issue, but for this question, supporters of Prop 62 and 66 both argue that their preferred initiative will save taxpayers money. But when it comes to heinous crimes like those that carry a death sentence, is this really a dollar and cents issue?
I agree with you. I actually think if we think that something is worthwhile, there are many before school programs, Head Start, it costs a lot of money, it works, let's pay for it. There's a lot of child support issues that cost money, but if they work, let's pay for it. The reason I'm opposed to the death penalty is it doesn't work. We are not safer because we spend $5 billion with what an Orange County judge called life with the remote possibility of death, because that's what we have in California. So it doesn't work. We are not safer because of the death penalty. We would be safer, for example, if we had money that could go to more police on the street. I think San Jose has had a terrible problem with crime this year. I would bet that the mayor and other city officials in California would love to have more well-trained, sensitive, and thoughtful, community-minded police officers on the streets of San Jose, and we would be safer for that rather than the death penalty. So if it's a good measure and it's worthwhile, we should pay for it. The other thing is, and I've done many of these discussions with Steve Wagstaff, the San Mateo District Attorney, and he will tell you 66 will cost a lot of money for at least the first 10 years. The only way you can move something more quickly is to throw a lot of money at it, and I mean tens or hundreds of millions of dollars. But if you read Proposition 66, what's interesting is it's not funded. There is no funding provided in Proposition 66. And what they say is, we're just passing the measure, it's up to the legislature to fund it. So Proposition 66 cannot really go into effect unless the California legislature then allocates tens to hundreds of millions of dollars towards implementing the provisions they suggest. I think it's, again, unfortunately, another false promise to the public, a false promise to victims and victims' families, and just won't work.
Alrighty, so the last question we have as moderators before our audience questions is that opponents of the death penalty often argue that the death penalty doesn't actually deter crime because the punishment is so far removed in terms of time from the actual crime. Punishment isn't swift. Wouldn't Prop 66's proposal to speed up the pace of executions actually strengthen the death penalty's capacity to deter future crimes?
Well, the first thing is the premise of the question really doesn't work, is that there is actually no accepted valid social science literature that supports the idea that the death penalty is a deterrent. Even Justice Scalia on the Supreme Court, a big supporter of the death penalty, acknowledged that it's not about deterrence. There's no legitimate empirical evidence to support that. It's about retribution. It's about punishment. And so deterrence is not a factor with respect to the death penalty. If you want to be retributive, and I know if you're taking a punishment class, you know what that means, right? Then you can think about the death penalty. That is the purpose of punishment. And I would suggest if you want to be retributive, that putting someone in jail to die in prison is serious enough. The other thing, in places other than California where they do execute, and if we can examine Harris County in Texas, where it's certainly more sure, it's certainly more swift, and this is anecdotal evidence. I certainly wouldn't claim this shows it is not a deterrent, but the violent crime rate in that county has gone up. And recently they've actually even decided that the death penalty wasn't worthwhile. They've dramatically decreased its use in that county. But if we look in places that do not have the death penalty, there's no correlation to violent crime. Actually, nationally, if we look at counties that implement the death penalty across the country, It's 16 counties around the country are responsible for almost all of the death sentences that are imposed and handed down in the country nationally. So there's not this broad appeal for it. There's not the broad outcry for it. California had about 4 of the counties on the list down in Southern California.
Okay. So right now we're going to be taking questions from the audience. Alrighty. So here's the first question. Do you think there is a disparity in locations that use the death penalty disproportionately towards people of color?
So when I started off, I said that the death penalty is arbitrary. And the arbitrariness is that we look at how the death penalty is imposed. And it's imposed both nationally and locally in California disproportionately in a couple of ways. One is geography. As I said, in California, and there was an empirical study done by a social scientist, Michael Radelet, that identified the counties in which the death penalty is imposed. But the other one that I think is more troubling for our criminal justice system and should be troubling to us as citizens who study this and care about criminal justice and social justice is that nationally, for decades, every study that has looked at the imposition of the death penalty, the single most significant statistic that impacts whether they seek the death penalty, whether you get sentenced to death, and whether you get executed is the race of the victim. And when the race of the victim is white, depending on which jurisdiction it is, the proportion, the likelihood, the statistical increase in the fact that you will get the death penalty, that they will seek the death penalty, is higher. If we couple that with the race of the defendant, now most crime is not intra-racial. Most of it is white on white, black on black, but when we look at how it's imposed, and then we add the race of the defendant, that can increase the likelihood even more. But the single most statistically significant factor is the race of the victim. And that has been the case in every study that has looked at it, whether it's a statewide study, a national study, a pro-death penalty, an anti-death penalty. And unfortunately, this kind of evidence was presented to the Supreme Court in 1987 in a case called McCluskey versus Kemp. And you should all read this case because it really should be hanging up there in the Supreme Court Hall of Shame in one of the most horrific opinions the court handed out. And in that case, extensive statistical evidence was presented to the court with 230 variables, and I'm sure all of you understand statistical evidence a lot better than I do. But when they controlled for this information, again, that early finding that the race of the victim was as compelling as whether or not the defendant had had a prior homicide conviction, the race of the victim was the single most statistically significant factor. And the court looked at that, and they would not strike out down the death penalty, but their opinions are interesting because they did not question the validity of the statistics when they ruled that way. They said, accepting the statistics in that way, we are still not going to hold that the death penalty is unconstitutional, because what would that do to our criminal justice system? And what I say it does is death is different. And it's not that our criminal justice system isn't also plagued with issues of race and racial bias, but we cannot tolerate it when we are taking a life. We cannot tolerate it in those circumstances.
Our next question from the audience is, what specific factors makes imprisoning someone on death row so much more expensive than a life term without the possibility of parole?
It's a good question, and there's a lot of security regulations that are actually put in place by the prisons in terms of how they manage it. So individuals on death row are single-celled, whereas in other prisons they're either double-celled or they're actually bunked in triple bunks in gymnasiums. Instead of being used as gyms, it's just filled with triple bunks across the gyms. The inmate to guard ratio is higher. Whenever someone is moved, there are additional precautions that are imposed. I've met with Sam Robinson, who's the public information officer at San Quentin. He's come to my class at Santa Clara a number of times. And we've talked to him about it, and he actually said that they have no interest in having people on death row commingled with the rest of the population, because death is different. It puts a different aura on the people who are condemned to die. But he said many of those persons, should the death penalty go away, could be reclassified and put in other prisons. Now, interestingly, Prop 66 says they will save money because they will not require, but they will allow the Bureau of Prisons to make that decision to distribute them throughout prisons in the country. And it's an interesting part of the provision of Proposition 66, because I can assure you that prisons do not want to do that. They feel the safest, most secure way to handle persons on death row are by keeping them in one building. They're all in San Quentin, except the women who are in Chowchilla, and they can have the control, the security, and the additional safeguards that they think they need.
Thank you again. So for our last audience question, does Prop 66 say anything about changing the method of execution? Current lethal injection procedures have been challenged as violating the Eighth Amendment ban on cruel and unusual punishment. For example, does Prop 66 address this?
They do. I'm trying to remember exactly how it's worded, so I don't want to make a mistake and misstate it. Let me back up. The question about the method of execution is a good one. The method of execution is now promulgated by the Bureau of Prisons. One of the interesting things in California today is that currently, as we sit here, there's actually no execution protocol that is in place. So if everything went away and they said, okay, tomorrow you can start executing people, we actually can't because there's no execution protocol in place. In 2006, when our last execution had taken place, Federal District Court Judge Fogel, actually here in San Jose, held several days of hearings. And he held at that time that the death penalty, as it was implemented in California, was unconstitutional. And he was relying on not the death penalty in the abstract, but in the way it was carried out in California. And he added, it can be fixed. We're now 10 years later, we haven't really fixed it. To give you a window into some of the things that he found wrong, because he went up to San Quentin, he had them replicate how are these executions taking place. At that time, they used 3 different drugs. The first one was a barbiturate, the second one was a paralytic, and the third one was potassium chloride that stops your heart. And so the controversy a lot was, if the paralytic's in place, if someone is experiencing excruciating pain, there is no way to see it. And when he reviewed the handful of executions that had taken place in California thus far, there was evidence that some of these inmates, looking at the jail's own observation records, may have still been conscious. There was breathing patterns that were shown, movement that was shown. And that meant the barbiturate did not put them in an adequate anesthetic depth. So it means the potassium chloride may have imposed an extreme amount of pain, but no one could see it because of the paralytic. And the district attorney and the attorney general quite candidly admitted there is no medical or death cause that actually is served by the paralytic. It simply makes it easier to watch. The new protocol that was then issued last year and has been put out for public comment recommends a single drug. And I think what Prop 66 talks about is that these protocols should no longer have to follow the same extensive procedures that are required now. And they don't, and that's how they talk about the specific drug protocol. The problem is, though, it's actually very hard to buy these drugs. You may not know it, but in the European Union, you cannot be a member of the European Union if you have the death penalty. No European country has the death penalty. And I say that because it relates to the drug protocol, because they have forbidden any of the pharmaceutical companies or any of the European companies to export these drugs for purposes of execution. American companies have taken that position on their own. The pharmaceutical companies have said, we're companies that want to heal. We are not companies that want to kill. And what's been happening in some of the other states that have had executions is they have gone to some compounding pharmacies and other drug companies to try and get substitutes. Well, the last execution in Oklahoma and Arizona, they were using a drug, Versed. It's an anti-anxiety drug. You don't have to raise your hand if you've been taking it, but some of you may have heard of it. They're anti-anxiety drugs. They are not barbiturates. They are not designed to put people into a deep anesthetic depth. They are not drugs to ultimately kill somebody. And those are the drugs they're using to sedate people now before they administer the drugs to kill. Not surprisingly, these states had 43 minutes of people writhing and being in pain before they finally died. It's been a nightmare. And so the California protocol, which is in the process of being written, evaluated, responding to public comments, has not been re-released. I don't know when that will happen or exactly what the specifics of it will be.
Alrighty, that concludes our audience questions. I want to thank you again for coming to our panel interview.
I could say one last thing?
Yeah, sure.
All right. So the one thing I would say to everybody, because I think all of us could actually think about a crime that is so horrific, or an individual who does something that is so repulsive or frightening to us, that we might actually be able to say, I could see that that person might deserve to die. But I'm a lawyer. I'm a person who's about process and procedure. And I have a very dear friend whose name is Brian Stevenson, who has done death penalty work since the 1980s. And he says that and this is the question I would put to you, that the question we should be asking ourselves is not whether an individual deserves to die, but whether or not we as a society deserve to kill. And I would say to you, and I've been working on death penalty cases since 1982, I was 12, is that we don't deserve to kill. We don't deserve to kill because the system that we have in place, and I assure you, if you accept the death penalty, you have to buy the package. You cannot say, I want the death penalty because Mr. So-and-so did something that's horrible. Death is the only answer. You cannot accept the death penalty because you say, I heard about a crime. Death is the only answer. You have to buy the package. And the package in California means we will execute innocent people. You will get the death penalty not because you have the worst crime, but maybe because you had the worst lawyer, or you were in the wrong county, or the prosecutor engaged in prosecutorial misconduct. A lot of reasons that have nothing to do with a really fair, reasonable, appropriate measure of whether or not you should get death. And for that reason, you should be voting yes on 62, which says you will die in prison. You will die in prison, but the state will not kill you. And you need to vote no on 66 because it's a false promise that will do nothing to make us safer.
Thank you again, Professor Kreitzberg.
Thank you.
Good evening. My name is Garrick Percival. I just wanted to say a few remarks while we finish up here tonight. First of all, thank you for everyone who took time out of their busy schedules. Our three speakers, Helen Kreitzberg, Sam Brady, and Jeff Rosen, and our three moderators, who I think did a fantastic job tonight. So get a big round of applause for them. As Jose mentioned at the top of tonight's program, that there are 17 initiatives in California. California asks a lot of us as citizens in a democracy, and one of the things when we have so many initiatives like this, the key point is to get informed, study the initiatives. You can get lots of really good information on each of the 17 online, and it's a great way to do that, to take some time, even in the next couple of weeks, to do that. Also, Proposition 66, which we talked a lot about tonight as well, their campaign was unable to join us, but you can go online and get lots of information from that campaign as well if you want more details on that initiative. A couple additional things. We've got a table outside. Some of you may have seen that on the way in, which allows you to fill out a voter registration form. So if you are New voters, they just recently turned 18 in the last year or so. Between now and the last election, this will be your first election. It's really important that you get registered to vote. We have voter registration cards right on the table. You can fill it out there, and we'll have folks that will turn that in for you in time to vote on November 8th, which is our general election. The last day to register to vote in order to vote in this next election is October 24th. And so you can also register online here. So just the most important thing is just get registered. Also, we have, I know many of you here from other classes and professors across the social sciences and across campus. Those professors who have notified that they are encouraged their students to attend tonight. We have 3 tables set up out in the foyer out there that you can find your professor's name, sign your name. You can sign any one of your professor's sheets with your class on it. You don't have to go to each of the 3 tables to do that. Just find one sheet with your class, sign your name, and that will take care of that end. So again, thank you very much. Keep informed. Go vote on November 8th. Thank you very much.